Judicial mediation at the state courts. Resolve your cases in court through judicial mediation. In the heat of anger or frustration, it is often easy to want to sue the other party in court. However, going through a court trial can be a lengthy and costly process. The rules of court thus require parties in civil disputes to find ways to settle their disputes amicably without going for trial. One way is to settle your dispute at the state courts. More than 80% of the civil cases filed in the state courts that went through the court dispute resolution process were settled amicably. A variety of court dispute resolution or CDR modalities are utilized during the judge-led case management process at the state courts. Judicial mediation is one of the CDR modalities used by the state courts to help parties to resolve disputes early without the need for a trial. Mediation is conducted at the state courts as part of the pre-trial case management process. It can be conducted face-to-face or through video conferencing. Mediation allows the disputing parties more control over the outcome and reduces the time and costs involved in resolving the dispute. During a mediation, you will meet with a mediator. The mediator presiding over your case will either be an experienced judge or an accredited mediator on the state court's panel of court volunteer mediators. If you have engaged a lawyer to represent you, your lawyer will also attend the mediation with you. If you do not have a lawyer, you can still attend the mediation by yourself. In a mediation, you and the other party have control over the outcome of your dispute. The mediator will not judge or determine who is at fault in your dispute, but will help you and the other party along in your discussions to find solutions that will meet your concerns and needs. Parties also save time as their disputes are resolved earlier. By reaching an amicable solution through mediation and avoiding a trial, you can save on litigation costs. What you and the other party discuss with the mediator during the mediation session will be kept private and confidential. Anything said by you or the other party will not be used against you as evidence, even if your case proceeds to trial. Mediation focuses on solutions, not legal positions, and the process is more flexible and informal than a trial process. What can you expect before, during, and after a mediation session? Ensure you have thought about and discussed the key points with your lawyer, such as your main concerns and what you would like to achieve at the end of the mediation. For example, in order to settle the dispute, do you need monetary compensation to preserve the relationship with the other party, or an acknowledgement of wrongdoing? You should also consider the offers that you will be making to the other party, how the other party is likely to react to your suggestions, and possible ways of settling the dispute. The session will start with the lawyers briefing the mediator on the facts of the dispute and what is to be discussed. You and the other party will then be called in to join the mediator and lawyers. Each of you will be given a chance to speak about the dispute. The mediator will then facilitate a discussion on the issues presented. Always keep an open mind. Be prepared to share your views and to listen to the other party. When necessary, the mediator will hold separate meetings with each party, together with your respective lawyers, for more in-depth discussion and to explore possible solutions for settlement. All the information that you share with the mediator is confidential and will not be shared with the other party unless you agree to do so. Once you and the other party have reached a settlement, you will review and confirm the terms of the settlement agreement or consent judgment, which will then be recorded before a judge. A court-mediated settlement is binding on the parties and must be carried out according to its terms. Any failure to comply with those terms by any party entitles the other party to enforce the settlement as a court order without having another hearing before a judge. If no settlement is reached after the second or third mediation session, the dispute will proceed for trial. There are many advantages to resolving disputes through mediation. You can find out more about the mediation process on the State Court's website.